All right, we're going to go ahead and get started, everybody. Thank you. I want to introduce the moderator of this panel, Rich Glaze. Rich is a partner at Barnes & Thornburg and previously served as enforcement counsel for the EPA in Region 4 here in Atlanta. And Rich has been doing a lot of this work in private practice after he left government. He's really a leader of the bar in Atlanta and the Southeast in this space, and it's a topic that we've discussed wanting to have it at this program, and so we're happy to have it here today and led by Rich Glaze. Thanks, Rich.
Thank you, Brian, and thanks so much for the opportunity to talk about this topic, which should become more and more important as the money from the Biden administration flows through EPA to CID and as they hire more and more agents to tackle the worst environmental violations in the country. So today we have an all-star panel. They're going to help us walk through environmental crimes and some of the nuances that are important for understanding how to defend clients in environmental crimes cases. And I'm going to start, go from right to left, or I guess that's stage left to stage right. Nevertheless, Mike Fisher on my left is the director of the Legal Counsel Division Office of Criminal Enforcement, Forensic, and Training. We called it OCEFT. This means Mike is the top attorney in EPA's criminal enforcement program, a position he's held for the last 15 years. He spent a decade before that as a criminal enforcement counsel in what region?
Region 3, Mid-Atlantic.
Region 3, and a special assistant U.S. attorney in several U.S. attorneys' offices. Mike has a JD from Yale and a bachelor's degree from Rice. I think it's fair to say, given his position and experience, that Mike's one of the most knowledgeable and experienced federal environmental crimes attorneys in the country. He was an indispensable resource to me when I was a criminal enforcement counsel at EPA, and I know Mike to be a terrific lawyer and a very nice guy, and we're happy to have him on the panel. To Mike's left is Robert Posey. Robert Posey is an assistant United States attorney, actually an executive assistant United States attorney in the Northern District of Alabama. He has 40 years experience in prosecuting in both state and federal courts. He served 32 years as an AUSA and is previously was an acting U.S. attorney, a first assistant U.S. attorney and chief of the white-collar crime section in the Northern District. Robert earned his JD from Cumberland School of Law at Samford University and his BS from Washington and Lee. He's tried a variety of criminal cases and currently concentrates on civil rights, environmental crimes, and other white-collar crimes. Robert's received many, many awards because of the excellent work he's done during his career. As an example, for his superb work in the prosecution of McWane Corporation for environmental crimes and fatal workplace crimes, he got a silver medal for superior service from US EPA, and the National Association of Former U.S. Attorneys presented to Robert the Michael Bradford Memorial Award, which is awarded annually to an AUSA for outstanding performance. And I've always been fascinated by this aspect of his career. In 2001 and 2002, Robert worked with U.S. Attorney and later Senator Doug Jones to convict Thomas Blanton and Frank Cherry for the 16th Street church bombing cases in Birmingham, where 4 teenage African-American girls were killed when the Ku Klux Klan bombed the church during Sunday services. I had the privilege of working with Robert as a special assistant for several years, including during the McWane prosecution, and I can attest that Robert's a skilled, committed, and level-headed prosecutor. Thanks for joining us today, Robert.
Thanks, sir.
Lisa Rushton, to Robert's left, is an industry-leading environmental attorney who for more than 25 years has guided corporate clients, including global, multinational, and local corporations, real estate developers, and local on matters related to federal, state, and local environmental health and safety regulations. Lisa has substantial knowledge and experience with virtually all environmental matters, including those related to air and water pollution, solid and hazardous waste management and cleanup, and toxic substances control laws. Many of the laws related to Lisa's experience have felony provisions that are very similar to the ones that can be enforced civilly. So in advising her clients, Lisa must be able to recognize when the potential violations become criminal cases and apply her comprehensive environmental knowledge to keep them out of harm's way. We're very pleased to have Lisa here today and hear her perspectives during this conversation. And last but not least, Emily Ward recently founded the White Collar Practice at Continuum Legal Group in Atlanta, where she combines her experience in big law at an Atlanta white-collar boutique and as an entrepreneur in the restaurant industry to defend and advise companies and individuals in white-collar matters. She's involved in government internal investigations, complex civil litigation, and other matters requiring her diligence and intelligence. She also, I can attest that Emily is an experienced environmental lawyer because I've worked with her for 6 years on a complex environmental case where she has been sort of gotten trial by fire in a very difficult case. Emily received a BA from the University of Miami and a JD from Georgia, and she's the incoming president of the Atlanta Bar Association. So in her relatively short legal career, Emily's earned more than her share of awards. One that stuck out for me recently was when she and her husband, Joey, were both named as top 40 professionals under 40 in Atlanta. So with that, we'll get started and hopefully give y'all some insight on some of the environmental crimes issues. So I want to start with Mike. Mike, can you start off and give us a description of EPA CID's mission and a brief history about why EPA criminal program was created and which added felony provisions to the existing EPA statutes at the time?
Sure, I'll try to do that in 90 seconds or so. The criminal enforcement program at EPA employs around 160 criminal investigators who some people are surprised to hear are EPA employees, but they're just like any other federal agents. They're gun and badge carrying folks with arrest authority and warrant execution authority that's commensurate with the FBI. So it spans the U.S. Criminal Code. And they were brought into being by the Reagan administration. First in kind of a trial mode as Special Deputy U.S. Marshals, and then the Reagan administration sought law enforcement authority from Congress, which passed a statute, Title 18 provision 3063, which confers that law enforcement authority on our 1811s. The reason for that interest by the executive branch during the 80s was that the environmental problems that prompted all of our federal legislation, which familiar to most of you probably at a high level at least, Cuyahoga River catching on fire, residential communities being built on hazardous waste dumps. Those statutes that Congress passed in the 70s all had criminal enforcement provisions, but they were all misdemeanors originally. And they did not generate federal prosecutions for the most part. DOJ had begun to use a much older statute, the Rivers and Harbors Act, to address the first and most kind of egregious instances of water pollution. But after Congress passed the Clean Air Act, Clean Water Act, RCRA, which regulates hazardous waste, not much was happening in terms of federal criminal enforcement, but a lot of bad behavior was continuing. So Congress embarked on a campaign to kind of upgrade the penalty provisions of each of those statutes, and it did that first in RCRA in 1980 and in 84, then in the Clean Water Act in 87, the Clean Air Act in 1990. So those kind of big three environmental statutes have felony provisions, and other more specialized, less used, but still important statutes, like the Safe Drinking Water Act, FIFRA, which regulates pesticide use, also all have criminal provisions.
Thank you, Mike. Now, Lisa, drawing on your experience as an environmental lawyer, can you give an overview of the primary federal environmental laws that can result in both civil and criminal enforcement?
Sure. Most transgressions in environmental law really are addressed through administrative and civil enforcement actions. But when there's significant enough harm and culpable conduct, most really of the major environmental statutes really do, as Mike indicated, have felony provisions, misdemeanors built into them these days. The most commonly pursued crimes of the years really have been with regard to hazardous waste, clean water, clean air, and with regard to that, focusing really on the Clean Water Act, that may have a slightly lower threshold than some of the other statutes for the criminal provisions. But with regard to that, individuals could be prosecuted if they discharge pollutants to waters of the U.S., into wetlands, if they discharge hazardous pollutants into, again, waters of the U.S. or the surrounding zones, if they discharge and violate pretreatment standards, causing a POTW to exceed its limits or violate its permits, or discharging without permits at all. All could be subject to civil or criminal provisions. Similarly, the Clean Air Act has a large number of provisions that could be pursued either civilly or criminally. Things like if an owner or operator constructs or operates a facility without seeking a permit, if they violate one of the national emission standards for hazardous air pollutants, the practice standards, or the limits that are set in those. Specifically, one that we see a little bit more enforcement with regard to asbestos, with the demolition and renovation. If there's more than a certain amount of asbestos, and the practice standards for removing the asbestos or disposing of that asbestos are ignored, there could be civil or criminal prosecution with regard to that. Under Title II in the Clean Air Act, we have the motor vehicle provisions. So some of you may have heard in recent years about Dieselgate and some of the other large criminal prosecutions that have gone on with regard to tampering with emissions. And then there's the stratospheric ozone protections within the Clean Air Act also. Moving on beyond that, Mike also mentioned RCRA, which is the Resource Conservation and Recovery Act. That really deals with the treatment, storage, and disposal of hazardous waste. So if individuals knowingly discharge, transport, or store hazardous waste without a permit, if they transport waste without a manifest, if they falsify manifests, destroy them, don't retain them, all of them can be subject to either criminal or civil prosecution. Similarly, we've got the CERCLA and the Emergency Planning and Community Right to Know Act. Those have provisions that could be civil or criminal if there is a release to the environment that is above a reportable, kind of a set standard, and it's not reported to the government properly. That certainly could subject individuals to civil or criminal. And then, as Mike mentioned, there's FIFRA, which relates to pesticides. We've got the Hazardous Material Transportation Act. I can keep going. There's the Species Act, the Migratory Birds Act, TSCA, the Lacey Act. So bottom line is most of the major environmental statutes today do have provisions that can be prosecuted either civilly or criminally.
So you're saying we're going to stay busy?
Yes.
Well, I want to turn back to Mike. Mike, let's describe how CID is set up. And I know you've talked about the investigators you use, but explain briefly how they make their cases and how you transfer them to the Department of Justice for prosecution.
Sure. The criminal enforcement program at EPA is run out of headquarters, but it's got field offices around the country, including here in Georgia. And as I mentioned, the criminal investigators themselves are our biggest kind of bucket of staff, if you want to think of it that way. We sometimes talk about the three-legged stool of the program. It includes those 1811s. On the one hand, we've got a group of scientists and engineers that work at a forensic facility in Colorado and do nationwide kind of flying case support to take samples during search warrant executions and analyze suspected materials to testify about hazardous waste status or what have you. And then third leg of the stool are a fairly small group of attorneys. A couple of my colleagues and Rich's successors in Region 4 are here offering moral support. Jennifer Lewis and Keith Weisinger. It's good to see them. They are Regional Criminal Enforcement Council, or RCECs, in the alphabet soup that we use at EPA. I appreciate Lisa decoding my unconscious reference to RCRA, the Resource Conservation Recovery Act. She mentioned POTWs, which are sewage treatment plants, essentially, publicly owned treatment works. If I lapse into more alphabet soup that puzzles anyone, please just shoot your hand up and say, what's that? And I will backtrack and spell out the abbreviation. But in a nutshell, those three disciplines of EPA employees, the investigators, the scientists, the lawyers, work together to develop cases when we receive leads, which come in from a wide variety of sources, kind of similar to what you heard from the U.S. attorneys in the previous panel. And then we present those matters to DOJ for prosecution and occasionally to state partners if there's a jurisdictional bar or if the matter doesn't rise to the level of federal prosecutorial interest. We'll work with a state AG's office or a district attorney's office.
Okay, I'm going to ask you another question, Lisa, and then I'll turn to the litigators for a while. Okay, so can you sort of compare the EPA civil enforcement framework to that of CID?
Sure. Yeah, EPA's compliance and enforcement program is really run by its own personnel, similar to the criminal level. And then also via delegation to states when the delegation to states when to state agencies when the programs have been delegated, and sometimes even to municipalities, such as with regard to food treatment standards that are discharged into DOTWs, which we now have defined. The Office of Civil Enforcement within EPA basically.
Lisa, she asked if you could speak louder. Maybe
Oh, sorry.
the
Yeah.
microphone up.
Sorry about that. Yeah, the Office of Civil Enforcement within EPA develops and prosecutes basically the administrative and civil cases for them, and that provides legal support for the regional offices for their cases and their investigations. EPA can bring its own administrative and civil cases, but if a case becomes more material, if they want to seek maybe some long-term injunctive relief, for example, if there's a Clean Air Act where violations may exceed about approximately like $356,000, they will refer those cases to DOJ. Parallel at the state level, the state agencies will refer them to the state attorney general's offices for prosecution.
Thank you, Lisa. Okay, turning to Robert. Robert, you've investigated and prosecuted environmental crimes over the years. How are complex regulatory matters like environmental cases different from other white-collar cases your office brings? And are there other categories of cases that it's comparable to?
Yeah, one thing about environmental crimes is that they are more likely to have a business organization as a defendant than the normal kinds of white-collar crimes we do. So that calls into operation all the factors regarding selection of cases and punishment and things like that arose in the wake of the Enron corporate fraud thing. So the departments have been developing since the Thompson memo in 2003 these principles of how do you prosecute a business organization, what do you consider, and most recently last year in Dag Monaco's memo. But because you often have a corporate defendant, they're similar to corporate fraud securities.
Excuse me, Robert, can you put? Oh, there you
All
go.
right,
We're on.
that better?
Thank you.
Similar to corporate fraud, securities fraud, public corruption, and things like that. But again, the organizational component brings up a lot of stuff that's different from normal cases.
Okay, thank you. And another question for you, Robert. environmental is one of the subject matters for which the Department of Justice has special sections, and one of them is the environmental crime sections. When you get a referral from one of EPA CID's special agents in charge, what role does ECS typically have, and what's the process that determines how they get involved and how you sort of divvy up the responsibilities between ECS and the U.S. Attorney's Office?
Yeah, our office has a long-standing, really good relationship with ECS. So anytime, if EPA doesn't call them in, we always want ECS because they're the experts. They have great lawyers. They have great support staff. They're litigation support folks. They're paralegals are just terrific. They've got the environmental crimes manual online, so they are the go-to resource for U.S. attorneys on environmental crimes matters, and I think they're just essential to have in any environmental case we do.
Is there ever any conflict over settlement issues and that sort of thing? And if so, who has the final say in that?
You know, ECS can be tough to settle with, and but we always reach a mutual understanding of what the appropriate charges or penalties might be, and because we want to maintain that partnership. But yeah, I would expect that the locals would often settle easier than ECS does.
You said a lot. Thank you. That's very helpful. Okay, I want to ask Emily. I happen to know that you have recent experience working in long-running complex environmental cases. Can you talk about how cases like this are challenging for the defense, but how they also provide opportunities for the defense that a defense attorney might not otherwise think of?
Sure, and okay, I was going to make sure that my microphone was working since I know that we've had issues on this panel so far. On the challenges side, one of the biggest things that I've seen is just the amount of power and discretion that EPA, the Army Corps of Engineers, and even the state delegated agencies and entities have to either investigate or enforce the many different provisions that you had outlined. And so those challenges, it can really be daunting, even if it is a corporation, if it's a closely held corporation, a family-run organization. If you're going up challenging either maybe a permit revocation or an enforcement action where the penalty is $60,000 a day for every day that you're not in compliance, and if you don't have a permit, you're going out of business forever. Those kinds of onerous, really burdensome potential penalties, if you lose, can be really, really difficult for the not huge corporations or individuals. Success is also just far from guaranteed, even if you're just trying to get a permit, so that you are hopefully operating in compliance, because some of these, especially delegated agencies, have so much discretion, and a lot of things are sort of dependent on the specific situation. As Rich mentioned, I really got started on this by being thrown into the fire as an associate 6 years ago. And things that I just thought I knew, like what a pollutant was or what water means, I was completely wrong. And even as recently as this year with the Sackett case, the term waters of the United States, I think the SCOTUS has looked at 4 times so far, and we're still not totally sure what waters of the United States means. And pollutant can mean everything from nuclear waste to sand. So just trying to understand where that discretion is, because sometimes sand is okay, and sometimes it's a pollutant that now you have violated, something that might have a felony provision. And so those could be some of the real challenges, but like most lawyer things, it depends. Sometimes those can be really helpful opportunities, because if there is, perhaps a different interpretation of a word that is critical to your case, or something that has been interpreted a different way in a different part of the Clean Water Act or RCRA, then you might have an opportunity to make an argument that could be helpful to your case.
Okay, heads up, Robert, I'm going to skip to a question that has just become more relevant to set the stage. So Robert, some crimes are pretty straightforward legally in the sense that the elements of proof are all enunciated in a statute, like mail fraud, false statements, etc. But environmental crimes almost always require another level of proof. That is, that proof that a regulation was violated, and that regulatory violation in turn triggers a violation of the criminal statute in the Clean Water Act, Clean Air Act, or whatever. So what challenges does this present to the prosecution, and how do the prosecutors address these challenges?
Well, it is, for one thing, environmental crimes are unfamiliar to, I would say, most U.S. attorneys' offices. Maybe a few in Florida, California, or someplace do a lot of them, but I would say for most of the middle of the country, they're pretty unfamiliar. So the whole regulatory framework is unfamiliar. But a knowing violation, I mean, most criminal statutes say you have to have a knowing violation. A few things, tax cases, civil rights cases require a willful violation. So for a willful violation, you have to know that what you're doing is against the law. You intend to commit a crime. The knowing violation is that you intend to do what you do, and what you do happens to violate the law, but you don't necessarily have to know that what you intend to do is a violation of the law. But the whole permit thing, I mean, if you got a permit, you probably know what your permit says, and you know you're not complying with your permit, and you may or may not know that's also a violation of the criminal law. But I don't think the challenges of the knowledge requirement is all that difficult. In the kind of cases, in the kind of cases we bring, you know,
Okay.
I mean,
All right.
we don't bring criminal cases and environmental. You know, if it's just a difference of opinion among experts about whether they were in compliance or not, you know, it's got to be flagrant. And again, going through the factors of how you decide when you're going to charge a crime, it's got to be pretty flagrant. It's nice if there's some harm that we can show, but you know, just a violation of the continuing repetitive violation of the permit by an individual or an organization that knows very well what they're doing. And, you know, and I get it that companies are out there operating aging facilities, and many of the cases we've done, they were operating facilities that could not be operated legally. And there was an understanding between the company and our defendants that they would continue to operate illegally because they wanted to continue to make their product. And so I don't know if you call that a business decision or a moral decision or whatever, but it makes them appropriate targets for criminal prosecution.
Okay.
I'll just jump in to add to Robert's last comment and say, you know, environmental crimes are not just about money. They often involve threats to human health and the environment or actual harm. But they are almost always about making money or saving money illicitly. And one impact of that for responsible companies that are working hard to do the right thing is that they would be at a competitive disadvantage against folks who are cutting corners and making widgets on the cheap. If the government wasn't there to step in and take action against folks who are making the kind of conscious decisions to operate out of compliance with their pollution control obligations, like Robert mentioned.
That's very helpful, and I'd like to get into, at the end, is if we have time, talk about some concrete examples of that, because there's some specific crimes where that's really the prime motivator for a lot of your defendants. But let's get through some of the other background.
One thing, what Mike said, you're talking about making money, but there's, if a company is competing with a company, a foreign company, where that country doesn't really care about environmental crimes. They are at a competitive disadvantage for sure. And, you know, I don't know that federal prosecutors can do much about that other than, you know, do what the law says, but it's probably an area that somehow needs to be addressed.
Okay. Well, the environmental crime section chief is currently in Europe educating some European countries about that. So maybe you can circle back with her.
I'll call Deborah.
Emily, parallel proceedings. Environmental cases are often subject to parallel civil and criminal enforcement, including not only agency civil enforcement, but also third-party litigation by plaintiffs. So what from your experience, and I know you have it, what are the challenges of these parallel proceedings? And again, are there also opportunities with parallel proceedings?
I tend to love parallel proceedings simply because there are so many differences that can be both helpful and potentially harmful. But whether you're dealing with an administrative action or a state civil, maybe a private civil, and then perhaps a federal criminal, they're all going to have different burdens of proof, different abilities to either investigate or conduct discovery, to have sort of off-the-record discussions of can we resolve this, what are you looking at, maybe there's a misunderstanding of what your company is either doing or not doing, and utilizing those different opportunities if you're on the defensive side and you suspect something is coming down the pike later on, engaging in civil discovery perhaps in a more fulsome way than you might normally could be really beneficial, because you're then finding out things that you wouldn't be entitled to learn in discovery if it was a purely criminal matter. But then on the flip side, you probably want to be thinking about what your client may or may not be saying under oath, because it could be used against them later in a court of law. And if you weren't thinking about a criminal case later on, that might not be something that was top of mind. So there definitely can be a potential problem with it, but if you are sort of forward thinking about it, there really are opportunities, and hopefully if you're able to work with the regulating entities, you might even be able to prevent some future parallel proceedings.
Okay.
Rich, one thing to add to that,
Yep.
we've got some cases where we do have, you know, criminal prosecution going in parallel with a civil case, and the client perhaps does not stipulate it's against an individual, doesn't want to go to jail, wants to avoid jail time. They figure out a way to settle the criminal side of the case, but they don't want the settlement documents, the statement of the case, to impact what's going on in the civil case. So there has to be some thought and negotiation as to what's put into the statements that are put out on the record also in those cases. So there does need to be some strategy between the civil side and the criminal side.
Thank you. Thanks. So Robert, let's see, you already addressed that. So on the defense side, Emily, getting back to this regulatory complexity, is that, you think, for a defendant, and I know you've addressed this partially, but is that more of a hindrance or an advantage for a defendant?
It depends. I think it really is dependent on the situation. I believe Robert was talking about, I mean, if you have some flagrant, egregious, sort of black or white, it's probably not even all that applicable. But something I think we are going to continue to see as environmental litigation and prosecutions are brought more often, and just as businesses and how widgets are made gets more complex, and these aging infrastructures then get different superconductors or something that get included, things are going to get very complex, and trying to apply the different processes and definitions that are being used now with laws that were written or revised, you know, a decade ago, it's going to just take a little bit more interpretation, and that could give defendants an opportunity that the complexities of the actual statutes and rules and regulations, and then the interpretations that come on after that, there really could be some opportunities.
Lisa, you want to weigh in on that? I know you've seen a lot of that.
Yeah, so, I mean, we're definitely seeing that right now, and the case that came down last year, in fact, is a perfect example of the use of major question as to whether or not, the way EPA is promulgating rules or pursuing things, whether they have the right to do that or whether they are getting ahead of themselves and going beyond what Congress has, in fact, given them the authority to do. And so, as things are developing and changing, the issue of major question is coming up more and more in litigation.
Okay. Mike, let's talk about expert witnesses. I know EPA has a ton of knowledgeable and experienced folks, but do you have any particular group of people that you use for experts, or do you just use the whole agency as your resources?
We've got a dedicated group, like I mentioned, that does forensic support for our criminal investigations and for civil enforcement. And that's a laboratory out in Colorado, and they have not only folks who will take soil samples or take samples of suspected hazardous waste or asbestos and analyze those and be prepared to testify at trial, but they also have a toxicologist on staff, for example, who can talk about exposure issues at sentencing, where harm is a main subject of presentation to the court, or in a relatively rare number of cases where we actually charge an endangerment, which is the most kind of powerful criminal provision under those big three statutes we've been talking about, air, water, and waste. And it was also added in 2016 to TSCA, the Toxic Substances Control Act, now has an endangerment provision. And that's got an element of harm in the statute, and that's got a 15-year felony maximum penalty. So toxicologist is one type of expert used sometimes in the government's case in chief, oftentimes at sentencing. Those lab scientists I mentioned at our Colorado facility. And then we do draw on folks in other parts of the agency as well. For example, if we're working on a wetlands case, we don't have that kind of in-house expertise within the criminal enforcement program, so we would work maybe with somebody from the Atlanta regional office who's a full-time hydrogeologist and use them as an expert in one of our cases.
Okay, thank you. And Emily, can you talk about the use of expert witnesses on the defense side?
Well, I think particularly utilizing the civil skills that we have in litigation for Daubert challenges into the criminal arena, I think can be very powerful, not just because, we're right on the science or on the law, but where we are starting to deal with some very nuanced and complex both interpretations of existing regulations or really complex processes. Having someone who can explain to a jury something that is probably taking us way past what a layperson understands, and being able to break something down. You're taking someone out of that 701 into 702 as a witness, and so they're going to have to be an expert. And Rich, the case that we have, at one point we were both sides talking about 10 to 12 different expert witnesses to explain a case to a jury. And that's pretty unusual on the civil side if you're just talking about a run-of-the-mill case. But I think for something where you are dealing with really scientific, technical issues, it's very normal. But one of the challenges on the defense side is how do you get the information about those experts? Unlike on the civil side where you're going to have expert reports and depositions and all kinds of things going back and forth, on the criminal side you really only have Rule 16. You ask for disclosures, you get the opinions, and good luck. And so making sure that the defense, but also then the court, has enough information to actually hold a Daubert hearing is really important, and I think one of the sort of tensions on the defense side as we get into more scientific and technical issues.
Robert, do you have anything to add?
Oh no.
I would say that really in a criminal prosecution, if you've got defense experts, you have to have Daubert hearings. You have to hire experts for the government to educate the prosecutor on what the heck it is this person is going to say, and whether the information we receive in discovery is a legitimate area of expert testimony. I mean, it gets really, you know, I mean, I'm no scientist, so I've got to have an expert to read the book this expert wrote and tell me, you know, is his testimony consistent with what he says it's supposed to be? And is it even something the court needs to consider? So, yeah, it adds a level of complication, but the bottom line is the prosecutor has to be able to effectively cross-examine the expert. And to do that, if you first try to keep the expert out, second, you got to be able to cross-examine the expert. And that takes a lot of effort.
There's one controversy that seems to come up in environmental cases has to do with using experts to explain regulations. And judges often look, and opponents often look askance when you try to bring in an expert solely to explain what the law means. What's your view on that, Robert?
Again, I think you have to educate the court. You know, Mike mentioned Toxic Substances Control Act. So if a company has a TSCA order that says no release to water, you know, you don't want to get into arguments of, well, what do you mean by no release? I mean, by what standard? You know, is that detectable limits? Is that parts per billion, parts per million? Is it, by what test method do we determine whether there's, or, you know,
Right.
you know, so you got to have somebody that can educate the prosecutor about, you know, does no mean no, or does no mean sort of maybe, you know.
Sounds like parenting.
And convince the court, no means no, and the jury can understand that, and we don't have to have somebody to explain what no means.
Okay, Emily, have you had experience with that?
I don't know that I'd be able to go all the way into starting a very intriguing dialogue here, but I did want to add one aspect of the expert issue that I think is really important in just this entire discussion, is using experts on the front end, early on, because some of these issues are very technical, figuring out what, I mean, no always means no, but just figuring out what we're actually talking about. Some of the most knowledgeable people are folks who have worked either as enforcers or regulators for decades, and they are literally the people either that wrote the book or who have interpreted the book for decades. And if you bring in those kind of experts on the front end, maybe not even thinking you're going to be a testifying expert, but somebody who can help me understand what we're talking about, I think it can give you a level of credibility, because these are folks that, you know, they believe in the EPA, they believe in the Clean Water Act. These are folks that believe that there is a role for government and regulation, but perhaps not in this situation, or help you find this one nuanced area where there's a disagreement, but maybe it's a misinterpretation. And I think it's one of the ways that defense attorneys and government attorneys can really work together to narrow the issues and figure out, did somebody screw up? How do we fix it and move forward and really try to, you know, both protect the environment and help businesses and individuals do what they need to do too.
Okay, if I can jump in on this, on your question about so-called expert testimony at trial on what the regulations mean. I mean, we're all aware that the law is for the court to figure out and instruct the jury on. But there is definitely a temptation to have witnesses talk about regulatory content in some environmental crimes trials at least. And I think it's a temptation for both sides. The government is trying to explain, you know, what the inspector was doing at this 19th century factory that's being renovated into condos, and what they were looking for in terms of the asbestos that was ripped out of there without any containment or wetting. There's a right way and a wrong way to do that. And the right way is to explain the big picture point of the regulatory program and the pollution control provisions and the safeguards for public health and the environment. And the wrong way is to say the regulations say X, Y, and Z. And on the defense side, there's a good discussion of this in a Fourth Circuit case called Wilson, if folks are interested. A defendant often wants to come in, usually bringing folks like many members of the audience here who used to be in government and put them up on the stand and say, this is what a water of the United States is. I know because I was there when we wrote the regulations. And that's not kosher either. And the government successfully excluded that kind of testimony in the Wilson case. So, there are better and worse motivations for putting a witness on the stand to testify about regulations, but it's never, from my perspective, the right thing to do.
It's, well, you'd be surprised at how many people try it. No, you're not surprised. Okay, so what if you have a case where both sides are filing a dollar motion against the other person's witness who would get on the stand to testify about regulations? I'll withdraw that question, but that's how frequently, I think that illustrates how frequently the issue comes up. So let's turn to consequences. Mike, can you just sort of outline the consequences of being convicted of an environmental crime?
Sure. I mean, it's the obvious ones, right? For any white-collar practitioner, there's potential incarceration, there are criminal fines, there's restitution to victims. There are collateral consequences that sometimes make the calculus different and more complicated and can draw out plea negotiations, which is how the majority of our cases are resolved, just like any other criminal matter. But people who are doing business with the government can be subject to disbarment if they have certain types of environmental convictions. Clean Air or Clean Water Act crimes automatically debar the company at the location where the crime occurred, and EPA's listing and debarment folks, which are separate from the enforcement office, and they're in the part of the agency that deals with contracts and grants. They can take broader discretionary action beyond the site of the original offense. So that kind of collateral consequence is something to consider, obviously, and to navigate. And we've had mentioned, Emily mentioned, or Lisa, I guess, mentioned parallel proceedings issues, and the question of whether a criminal conviction is going to have a collateral estoppel effect on civil liability is another thing, obviously, to think about. Maybe a last point to make relates to crime victims. There was some discussion of that in the U.S. Attorney's panel, briefly and indirectly. That's an issue that EPA's criminal enforcement program has been working hard on in the last 5 to 10 years, I would say. We've kind of come late to that subject in comparison to people who do traditional law enforcement, street crime, sexual assault, the kind of things where you think intuitively about crime victims and their needs. But we are just as subject to the Crime Victims' Rights Act as any other law enforcement agency in the federal government. So we've been working hard to meet our obligations, and those include, pursuing restitution whenever that's available to a defendant, and we also think about community service projects that can benefit communities that might not fit the strict definition of a victim for restitution purposes, but have undoubtedly been adversely impacted by environmental criminal conduct.
Thank you. Robert, how do you characterize the seriousness of the punishment for environmental felony convictions in sort of the scheme of things in federal criminal law?
I think the punishment under the statutes, the available punishment, is good for an environmental crime. And
Well, let me just ask you, what does good mean for a crime?
well, so I've got a real life example. I'm not going to mention any names, but the defendant was convicted by a jury. The pre-sentence report said throughout the conspiracy, this was not only environmental Title 33 statutes, but conspiracy and some other crimes. Throughout the conspiracy, there was a mutual understanding between the company and the defendant that wastewater was to be disposed of illegally so that the plant could continue to operate. and the defendant either authorized the discharges directly or ordered workers to dispose of water illegally. Under the guidelines, had a base offense level of 8 under 2Q 1.2, and then you had specific offense characteristics that bumped it up, +6 for repetitive continuous discharge, +4 for violation of the permit, +4 for defendant authorized or ordered workers to violate the law. So, so you wind up with a guideline range of 41 to 51 months, which is for a white collar case high. But and this is no criticism of the court at all, because the guidelines are discretionary now. They were made mandatory because of low white collar crime sentences, but they're discretionary, and courts do the best they can. But in a white collar case, the court is looking at a defendant that's not your usual drug dealer, violent crime, which is what they see most of the time, and you've got a defendant who at sentencing brings in the leaders of the business community to testify to what a great community member that defendant is. And so here, defendants looking at 50 up to 51 months. You have testimony at sentencing, and the judgment order, defendants hereby sentenced to 36 months probation. So looking at 51 months gets 36 months probation. That's because, of the nature of the defendant, the nature of the crime. You don't have anybody who was shot or, any kind of personal injury. It's you may have conflicting expert testimony on whether there was harm to the waters of the United States or whatever part of the environment was affected. And, courts have a tough job and they do the best they can, but you tend to not get a statutory maximum, to say the least, not even a statutory minimum a lot of times.
Okay. Now, Emma, you've had some experience with this. You've received a pretty high guideline range threat from the environmental crime section attorney. Do you recall what that was and how they got there?
As Robert was referencing, it's not hard with many of the enhancements and specific offense characteristics to get a guidelines range well over 100 months. And we received one, it's been a little while, but it was starting at like 8 years or something, for an offense that there was an admission that there was no damage. But we're starting it at 8 years, and that's a really hard sell for somebody, just as it would be if you had a non-white collar defendant. So the 2Q 1.1 and 1.3, it's not hard with many of the enhancements, including for a special skill. If maybe it was an engineer at a plant or a lawyer was involved. If there were multiple people involved, and as Robert was mentioning, you told your employees to do something. It is not hard to get up well above 100 months.
Okay, but you've done some research about sentences in the Southeast for environmental crimes, right?
Just as Robert mentioned, the guidelines range it tends to be above what defendants who are sentenced actually get sentenced to, or judges tend to take more advantage of a split sentence or some sort of alternative to prison.
So, Lisa, I don't want to leave you out of all this. Do you have any comments on just consequences of environmental violations in general, and what they could be, and whether they're generally appropriate as handed down either in civil or criminal?
Yeah, from more of the civil context, there are a lot of guidelines on the civil side also as to, how the fines really that are associated with the civil enforcement actions. And there's definitely mitigation factors and ways that go up and down within that. I have found that as long as there's cooperation and good communication and coordination with EPA or DOJ, as the case may be, they do tend to be in the reasonable range for basically what's been laid out in statute. They can be extremely high because a lot of violations are per day in certain circumstances, and they don't tend to generally go to that extreme. So they tend to be in the realm of what we can expect and predict, and I've been able to fairly accurately predict where we're going to come in and not be far off with some guys I work with.
So you would say EPA is sort of faithful to their policies?
They do,
on
yes.
Penalties, okay.
Yeah.
So in the last panel, the U.S. attorneys were talking about self-disclosure relief from the Department of Justice. Mike, EPA has a self-disclosure policy, and if someone's, I'm not going to say if someone's under investigation, but could you explain that policy and how it can be used, when it can be, and when it can't be effective?
Sure. You can find it online. EPA has posted it on its website. It was published in the Federal Register, so Google search will turn it up in one place or the other. It has some of the same requirements that you heard at the previous panel from the U.S. attorneys. True self-disclosure, right? Not following a whistleblower into the government's office to try and explain away something that's already been reported, or even more inappropriate that the government's found out, through an inspection or something like that. Prompt disclosure, which we all understand creates tension, given the complicated subject matter and the number of players that you'll have to acquaint yourself with quickly. And I think everything you heard from the U.S. attorneys applies equally on that front with an environmental disclosure at EPA. Remedial action, cooperation. So those are all same kind of factors you would hope to see in a kind of a good government document to encourage cooperation without immunizing bad behavior and incentivizing strategic disclosures from bad actors. The EPA policy has some carve-out language for intentional misconduct. As a result of that, and perhaps more importantly, as a result of the fact that EPA doesn't decide who gets prosecuted and who doesn't, of course, that's the Department of Justice's prerogative, and that's their exercise of prosecutorial discretion. So in the criminal context, when folks have a disclosure to make that may be or is definitely something that involves potential criminal conduct, they often go directly to DOJ rather than to EPA with that. But if they do come to us, then the criminal enforcement program will talk to DOJ about the matter, investigate it, see whether it meets those criteria that we just laid out briefly, and then the carrot from an EPA criminal enforcement office perspective, if there is a criminal disclosure to us, is our recommendation to DOJ one way or another, which is helpful and welcome, no doubt, from the defense perspective, but not anything you can take to the bank. So perhaps you want to talk directly to Robert about a self-disclosure rather than to our office.
So if I'm in a regulated entity and I find a violation, and under the knowing standard, say I've known it, or my plant manager's known about it for a couple of weeks, and therefore has been a felon for 2 weeks. Is that something that's going to keep me from wanting to seek self-disclosure relief either? And would I, at that point, would that be enough to make me want to disclose to DOJ, or should I just stick with EPA to start with?
Yeah, it's a good question, and I think the kind of premise or the underlying set of issues there relates to what we were talking about at the outset of the panel discussion, the kind of mens rea standards that apply to these criminal offenses and the types of violations that occur. We were talking yesterday at lunch about some research on about a 15-year chunk of environmental crimes prosecutions by University of Michigan Law School, and in fact by a former professor there who is currently our assistant administrator in EPA's enforcement office, who some of you know because he worked on the Volkswagen monitoring project, David Ullman. Practically speaking, what his empirical analysis of thousands of environmental prosecutions over a 16-year period showed comported with his experience as a DOJ prosecutor for the first 17 years of his practice at the Main Justice Environmental Crime Section, which Rich and Robert were talking about earlier. And that's that cases that actually get prosecuted criminally have a relatively finite set of predictable and specific aggravating characteristics. Perhaps the most obvious of those is elements of deception or concealment of the conduct. If you've got folks engaging in ways that evidences a consciousness of guilt, and you want to make a self-disclosure about that as the organization after you find out about it happening in your corporate kingdom, then as the disclosing entity, you may well get significant benefit, but you can bet that the government will be interested in pursuing a case about individual accountability. And if that conduct is more widespread within a business organization and it goes into upper management, then it's by definition going to be of great interest to criminal enforcement folks. So that issue of kind of honest reporting, or on the flip side, concealment, false statements, false documents, is probably the defining characteristic of environmental violations that get handled criminally. But there are others as well, and you can Google David Ullman in Michigan and environmental crimes and see what the research says for yourself. But it is repetitive violations, it's actual harm to the environment, or it's trying to fly under the radar outside the regulatory system altogether. Those four types of aggravating factors together constitute 97–98% of the federal environmental criminal prosecutions in that pretty extensive time period that David and his Michigan law students studied.
Lisa, let me start by asking you how EPA gathers information for civil investigations, which under parallel proceedings can ultimately be evidence in a criminal case, and then follow that up by asking you whether you would ever advise a client to deny access to their facility to an inspector, either coming randomly to the facility or with a scheduled inspection.
So compliance monitoring is really the key to how EPA really regulates the community under environmental laws. And with regard to compliance monitoring, I mean on-site monitoring and off-site monitoring, they're kind of the two categories of how they gather their information and check on facilities. The on-site monitoring is when you have the inspections, the evaluations, or the investigations. With an inspection, it may be a surprise inspection or a scheduled inspection. It could be very media specific, or it can be facility wide. When they go in and do these inspections, they will interview employees. They'll look at the operations, how the equipment's being operated. They can take samples while they're there. They can take photographs. They'll look at the documentation that you have on site, the permits that you have, the record keeping that's been going on. They may ask for copies of the documents that they have there. And so that's kind of the on-site monitoring. With regard to the off-site monitoring, what I mean by that is a lot of the permits that facilities have require submission of, for example, air emission reports on a quarterly or an annual basis, reporting the chemicals that you use, and just submitting a bunch of information to the government, which does need to be certified. And then they also, off-site may include whistleblowers or employees reporting that something's been done. And so they could issue requests for information, and then those need to be responded to by the company. They need to be certified and be accurate when they're responded to. EPA also can do what's called a show cause meeting, where they will alert a company that we believe you violated XYZ statutes or regulations. Let's have a meeting and let's talk about that, giving the company an opportunity to explain why it is not, or why it is in compliance and there is no violations, to clarify some perhaps miscommunications and basically show cause why EPA should not pursue an enforcement action. I think, go ahead.
No, that's great. So Robert, if all this information that's legally and properly gathered by the civil enforcement authorities can be used by your office in a criminal prosecution, right?
Yep.
Is there any limit? I mean, what's the protection to the regulated entity for having the evidence gathered in a civil case improperly used or unfairly used by the prosecution?
Unfair?
I know.
Yeah, I mean, our general rule is that civil can tell criminal side whatever they know, can't go the other direction. So, as other panels have said, the department policy now is to encourage compliance. And the policy is to offer incentives to encourage compliance. Because, I mean, industrial processes are so complicated, and the people that run the plant or that run the company, they know when something's happening. You know, the EPA delegates enforcement to the states. Some states are more serious about that than others. And so if you don't have the people that are generating waste that have the permit, if you don't have them cooperating with the government, you know, you're not accomplishing the goals of the program of either EPA or DOJ. So I think it's certainly a legitimate approach is to incentivize cooperation on the parts of the regulated community. You know, it remains to be seen. This policy came out last year, so it remains to be seen whether the polluters are sufficiently incentivized. But it's certainly, you know, the premise was that environmental prosecutions are down. Mm-hmm. You know, the premise of the Monaco memo is we're not doing enough. We're not doing it fast enough. We're not holding individuals accountable. And so this is, these policies are intended to encourage compliance. It is, you know, really the only way, I think, probably because of the complexity, to get widespread compliance.
Okay. Lisa, so what can I do as a planner? I know I've just discovered that there's a horrible condition in my facility, and the EPA is outside of the door just randomly or on a scheduled inspection. What should I do?
I'm going to answer that in kind of two ways. Do facilities say no to inspectors? On occasion, I would say most do not. Generally, and I think all of my clients that face this, they'll have a plan. Most, at least, companies that have experience and have plans for inspections, they know inspections are going to happen. They may ask the inspector to wait until they can get their in-house or outside counsel to come and join them. Clearly get a clear explanation as to why they're there, what's the purpose of the inspection, and then try and limit what the inspector is looking at and analyzing to what they stated they were going to be there for. Make sure that you retain copies of anything that they take, and definitely do like an exit interview with them to get their feedback as to what they saw and what the conclusions were from the inspection. If they have an incident that just happened, it may be a reason to say, we've got this, we've got to handle this, we really need to pay attention on this. If EPA is turned away for whatever reason, EPA has two options. They can reschedule another time to come back. There may be a valid reason for that. I had a client that had inspectors on site when they had an explosion. The inspectors left and came back. They did. They let them deal with it. They left and they came back another time. But also if they are denied access, they can simply go get a warrant. And it is a very low threshold for an EPA investigator to get a warrant. It's a health and safety reason, and they have a regulatory reason for doing an inspection. So they're going to be back very shortly with a warrant, and they'll just, they'll have no questions as to why you denied them. So unless there's a very, very valid reason, you're going to let them in and just try and control the situation as best you can.
And what about information requests? If I, as a company, if I get an information request and by answering it, I'm going to incriminate myself, what recourse do I have?
Not a lot. Yeah, you do need to respond to them, and you certify those answers. I mean, if you get a 114 request, you are obligated under the Clean Air Act, or 104, for example, under CERCLA, you are obligated to respond to that. You may ask for more time. You're clearly going to vet it by your attorneys, and you're going to be very thoughtful on how you answer, but you have to answer, and you have to answer completely. And if you don't, then there is criminal risk for
And so
falsifying
those-
documents or withholding evidence.
And those information requests are typically directed to the company,
Correct.
right? And the company doesn't have Fifth Amendment protection.
Yeah, they need to respond, and they need to certify those answers, correct?
But you can be creative or strategic about who's going to certify that.
Yeah, I mean, I'll just add, we're talking about civil information requests here and civil administrative warrants, just so there's no confusion about the line between our two subject matters. But I'll also say, kind of per my earlier comment about, false statements, concealment being indicia of criminal violations. If you were describing kind of the core characteristic of American pollution control law, apart from its kind of cooperative federalism structure that has both, U.S. EPA and state agencies working together, you would probably say that it relies completely at its foundation on self-reporting of information by regulated parties. So if you have a Clean Water Act permit, it gives you legal authority to discharge pollutants under certain limits into surface waters. You've got to monitor your effluent. You've got to report to the state agency, is usually the permitting authority, every month about that. And if you are doing that honestly, once in a while there are going to be violations, non-compliance, and to swallow hard and fill out the form accurately and give that form to the state agency is going to result in either no action because they're too busy to engage on a low-level one-time thing, or if it's something they've seen before, or maybe you take the initiative on your own as the permittee to fix it, and you're communicating with the regulators about what the source of that problem was and what you are doing to make sure it doesn't reoccur. That's just responsible compliance work in whatever context you're talking about. And when you're in that mode and dealing transparently and accurately, honestly with the regulatory folks, you're not going to see criminal enforcement people knocking on your door. If we show up, we're not going to ask to come in typically and go away if it's not convenient for you. We would show up with a search warrant and we would execute the warrant. So,
And your guns.
well, that's just an unfortunate part of American society, I'm afraid. But the point is the self-reporting, self-monitoring aspect of all the pollution control statutes is so critical that's a kind of a real focal point for our evaluation of whether to commit scarce resources to invest in a particular violation. And it should be, front of mind for corporate compliance folks and in-house counsel that getting that right is critical, and dealing with the regulators in a straightforward and transparent way is your best recipe for success.
If everybody did that, these people wouldn't need to hear this talk. We're about out of time, but we have some time for some questions, if anybody has any.
I have a question. Well, we start with the premise that we're all against environmental pollution and environmental activity that causes harm to the environment. Starting with that premise, right, as Americans in our country. And so we appreciate what EPA does, Mike, and thank you for your service, and also Robert for your service. I wanted to ask a question though about resources. In the last century, when I was U.S. Attorney, one of the challenges we had were resources. Actually, we had a lot of activity, but we couldn't cover all the bases. Do you think there's going, or is there a plan? Can you share with us what resources might be allocated, Mike, if there are any, to boost the numbers, if you will, of people at EPA and Robert at U.S. Attorney's offices to go after, not my clients, because my clients are always good, but the really bad actors out there?
Well, I guess I would start by saying what I have realized after 15 or 17 years in headquarters, watching the budget process play out and being sent home from work every few years because of government shutdown, one kind or another, is that trying to predict what Congress will decide to do in terms of resources is beyond my capabilities. But having said that, I mentioned that David Ullman is the OECA Assistant Administrator now. He spent, as I mentioned, first half of his career, 17 years at the Main Justice Environmental Crime Section. He rose from line attorney to section chief, where he spent his last 7 years. He spent the next 15 years at Michigan studying and teaching about and writing about environmental criminal enforcement. We've never had an EPA political leader who is so knowledgeable about and committed to successful and well-supported criminal enforcement. So that's greatly encouraging to us, obviously. And we are hiring agents now, similar to what you heard from the U.S. attorneys in the last panel. What the future holds, only Congress can say. But one thing that we have always had to do and will continue to do, if you look on EPA's criminal enforcement website, you'll see a document that basically lays out our case screening philosophy, and sometimes referred to as the Devaney memo after its author, the criminal enforcement director at the time. But it explicitly recognizes that we're a small program and we're never going to be able to get to every case out there that could be investigated criminally. And so our agents invariably look to partner with other federal and state law enforcement folks. And we've done that since I started 25 plus years ago, and we continue to do that. Force multiply is the term the agents use, and we look to team up and bring whatever investigative resources are available to a particular case that needs attention.
In terms of U.S. Attorney's offices, I think the key thing resource-wise, because long-term investigations, long-term trials are very resource intense. So we need to get to resolution more quickly, which is sort of a premise of the Monaco memo. We need to get to individual responsibility more quickly. And I like what U.S. Attorney Buchanan said. It's about trust, a lot of it, because the regulated community needs to trust the government to, if you own up to your misconduct, you will be rewarded. So we can get the resolutions more quickly and cheaply in terms of resources.
Thanks everyone for your attention, and it's been a lot of fun. And thank you, Judge.
Thank you very much.
Yeah.